Thank you. Thank you so much for that intro. It's a big picture of me. It's kind of throwing me off a bit. But thank you so much to the clinic for having me here to speak with you about these important topics. I know it's important because I know there's many football fans out there, and right now you're missing your games to be here with us today, and we really appreciate that. So that means you at least value and understand the importance of wills and estate planning. And so we won't keep you too long, but we'll try to navigate the terrain, as it were. Just by a show of hands, how many out there currently have a will or are familiar with the wills and estates process at all? I see one hand in the whole building. Okay, well that's very smart of you and wise of you, and you can learn a little bit more today. But that is not atypical. That is sort of how we will find that the vast segment, especially in our community, does not understand the importance of will preparation and estate planning. And so we're here today to sort of help you see the value of it and empower you to do the things that you need to do to make sure that your future is secure. So one of the problems or issues when we deal with estate planning and wills, and I think what part of it makes it a little bit off-putting is that it's a little bit morbid, right? We're talking about death and mostly death of family members, and no one really wants to think about that, right? We all want to, in our minds, believe that we're going to live forever, even though we all know that is not the case and not realistic, right? And so what I like to do, just right off the bat, because we're dealing with a little bit heavy subject matter, is I like to insert a little bit of humor into the equation, right? And so right off the bat here, you see, this is kind of fitting because Thanksgiving was not that long ago, but you have the turkey meeting with his solicitor, and he's saying, and Farmer Brown gets nothing if I die under suspicious circumstances, right? And so here's the turkey contemplating a time where many turkeys go missing, right? Thanksgiving, and he's writing this into his will. And so I thought that was a little bit funny in a way to sort of break the ice. Here's another one. The wife is meeting with her, the widow is meeting with her solicitors, and ever since my husband died, there's been no end of trouble with his estate. Meetings with solicitors, letters, papers, opinions from counsel, conferences, fees, litigation, expenses, briefs, court hearings, more fees, I don't know what. Sometimes it makes me wish he hadn't died, right? And so it sort of shows what was spoken about earlier, which is that, at a time when you're supposed to be grieving, at a time where a lot of emotions are high, you have all of these other dynamics coming into the fray, right? And that is sometimes what it feels like when you're dealing with estates. And so what we're trying to do now is sort of reduce it to a digestible way of you to take sort of wrap your mind around the concepts that we're going to be presenting. And I'll take it slow, and hopefully we gain progress here. And so where I like to start is sort of some, again, navigating the wills and estates process, but I like to begin with definitions, right? Because we want to define our terms that we will be dealing with before we get into the whole estate process, because some of them are counterintuitive, and many of them are legalese, right? They're words that I didn't even hear of before I even went to law school, and they're not really layperson's terms. All right? So we'll have a brief overview where we'll start off with the definitions, right? Then we'll move on to advanced directives. These are steps you take ahead sort of the will process, right? And it includes something called a power of attorney, and we will get into that a little bit more as we proceed. Another thing we will go over is what happens if you don't have a will, right? I asked as a show of hands how many people had a will, and 95% of the room did not, right? So we're going to have to figure out sort of what that means and what happens if you don't have one, right? So we start off with definitions. I mentioned something called a power of attorney, right? And so it's defined as documents in which a person grants power over his or her assets or personal care to another person. Okay, and we're going to go into this a lot more in depth. These are just the definitions to have your mind sort of trained in that way. A will, document that sets out a person's wishes and directions with respect to the disposal of his or her property after death. That's the key word. Power of attorneys are dealing with what happens before you die. Wills are dealing with what happens after you die. Next definition is a testator, right? A person who makes a will, normally in the male persona. So that's a testator and a testatrix, a person who makes a will, female. Okay? A trust, that doesn't mean that I have confidence in what you do, in terms of that phrase, but it's more a means by which money can be held by an individual or institution, the trustee, for the benefit of another, the beneficiary, according to the rules governing the trust. Again, you don't have to memorize all of this. We're going to go in depth on all of these a little bit later on, right? Again, intestate or intestacy, right? That is the state of dying without a valid will. That would be 95% of you here today who don't have a will. If you were to unfortunately pass before your time, you would have said to have died intestate, right? And the final word, escheat. That's, again, another word you're not going to find in normal vernacular, right? It's a forfeiting of ownership to the crown due to lack of heirs. And again, we'll get into that a little bit deeper as to how that can happen and what that means. But bottom line is you don't want to get into a situation where you're forfeiting ownership of your property to someone that you don't necessarily want to forfeit ownership of your property to, right? Make sense? Okay, great. So we'll start off the process with advance directives. Again, these are preliminary things you can do, again, ahead of your death, right? And that's the realm we're in, prior to your passing, right? Which is great. Again, we'll inject some humor into it for all you Marvel fans out there, right? You have Captain America and Thor sitting down with their lawyer, right? And their lawyer is talking about his origin story. He says, well, I was bitten by a radioactive lawyer and ended up with the power of attorney, right? And so again, power of attorney is a little bit counter. Yeah, you like that one. A little bit counterintuitive, right? That's not really what it means, right? But we're going to delve into it so we can move on. So what is a power of attorney? We're going to cover in this section defining what a power of attorney is, and we'll use the word POA so I don't get tired and have to say power of attorney 1,000 times, right? There are 3 types of POAs, right? The powers that are granted in a POA, the formal requirements in creating a valid POA, and this is important, right? You want to make sure that whatever document you're creating is a legal, valid document. It would be a shame to create a document that you think protects you or takes advantage or acknowledges your wishes, and then to come to find out that it really isn't a legal document and it has no power. That can have problems for you and definitely your family members who think they have a document that is valid. Okay? So, power of attorney. In Ontario, a power of attorney, or a POA, is a legal document that grants someone you trust the authority to make decisions on your behalf and represent you to others, as we mentioned before. This authority can be general or limited to specific acts that the attorney can perform. Some common acts include payment of bills, investing certain assets, sale of a property, or making health care decisions. Now, first thing off the bat to note with these documents is that obviously these are very powerful documents, right? We're talking about the person is essentially empowered by you, the grantor, to do anything that you'd be able to do, right? With regards to property. And so it's a very powerful tool, and you should seriously contemplate who you are assigning to be this POA or power of attorney, okay? This ability is given in advance by you, the grantor, of the document, okay? The power of attorney is something you never hope will come into effect, but it can protect your finances, health, and personal decisions if you were to become incapacitated, right? And incapacity can be a number of things, right? I mean, you kind of think about that, that's not going to happen until I'm 85 years old, but no one, unfortunately, knock on wood, nobody knows when that time will come, right, where you are not able to make decisions on your own. A great way to think of your POA is as a form of disability insurance. It helps protect you while you are alive. Remember, I had stated that advance directives, power of attorney documents, we're talking about while you are still here, Wills, that comes later on when you have deceased. Your attorney is responsible for making decisions about your property, finances, personal life, and medical care in the event of an emergency if you're unable to do so yourself. We said that already. In many cases, you can also help your attorney by outlining these decisions in advance. And so this is very key, right? You want to pick someone who's competent. You want to pick someone who understands, right, what your wishes and desires are. You need to sit down with this person. Don't pick like your best friend from college just because they're your friend, right? You need someone who's going to do what you want them to do in these any given situations. Okay? So as I stated before, unless you limit what your attorney can do, they can do almost anything with your money and your property that you can. So this includes doing your banking, signing checks, getting a loan, buying and selling and leasing real estate, buying consumer and, goods and services. All right? But the power POA is limited, right? Your power of attorney cannot make or change your will. Okay? They also cannot change who is a beneficiary on any insurance policy or registered plan, right? So we see that it's a very powerful tool, but it's not without its limits. Right, so these are things that should be rattling around in your head when you're thinking about these different documents. Right, a POA also cannot just arbitrarily make a new power of attorney for you. Could you imagine if that was the case? Right, the power of attorney is strictly for your wishes. So you have the wishes, you've granted that in someone else. They're to do what you outlined for them to do. They're not now supposed to go and make a whole brand new set of rules that you didn't agree to. All right. So now we have 3 different types of power of attorney. Okay, and 2 of the types deal with property rights, and 1 of them are more regards to your personal care and your health. Okay, so we're going to go over the first 2 that deal with property, and then segue into the one that deal with health, and they both have their different dynamics and interplay as to how they affect one another. Okay, so the first one we have is called a non-continuing POA, power of attorney for property. Okay, the jurisdiction we are in right now is Ontario. They recognize a non-continuing POA for property. So this type of POA ends, right, if you become mentally incapable. Right? We'll see how that differs to other types of POAs, which actually are initiated when you become mentally incapable. All right? And typically this non-continuing power POA is used for a limited time. So the example is, you're going on a trip to Jamaica, and you see this a lot in our community, right? And people who contemplate going on flights start getting a little bit anxious, right? For whatever reason, especially if you have a fear of flight. And so the client will come in and be like, hey, I run this business. I want to empower my uncle, right, to be my power of attorney. That means he's running the business while I'm on vacation to Jamaica. You don't see these type of POAs that often, right? Because it's a very narrowly tailored type of POA, but what it does is limits your exposure in the sense that it's not forever. It's for a limited brief time, right? Hence the word non-continuing, right? So that, for example, if you need assistance taking care of your financial affairs while you're traveling, that's what we just spoke about. Okay? Moving on to the next form of a POA, we have the continuing power of attorney for property. All right? So your continuing power of attorney for property is responsible for making decisions regarding your property finances if you are medically incapacitated, right? This includes paying your bills, managing investments, or even collecting money owed to you, right? So again, you see the contrast between the non-continuing is that this kicks in these situations where you're not able to do it for yourself, right? And then the power of attorney for personal care. And so this is the one where, you know, in the rest of the world, in movies, you see the person who has the authority to pull the plug, right? You've seen this in different soap operas or movies, and they're like, no, don't pull the plug, and this one person has the authority, and they're hanging over your deathbed, and so that's an extreme example, right? That's not necessarily all that it encompasses, right? But your POA for personal care can make decisions regarding your health care, housing, meals, and clothing, essentially anything related to your personal care, right? And so in this power of attorney, you know, you would empower whatever you want in there, right? It could be anywhere from a nursing home to do not resuscitate, like I said, with the pulling up the plug, to you see blood transfusions sometimes with religions or individuals who don't believe in that, right? You empower someone to say, hey, if I'm in a coma and they're talking about giving me a blood transfusion, you're to step in and say, no, that's not what his or her wishes are, okay? Your POA for personal care can make decisions. Like we said, this person is the voice of your health care decisions if you are unable to communicate for yourself. Like I said, you get into an accident, you're unconscious, you're in a coma, maybe you've lost the capacity or the mental capacity to make decisions on your own. This is where this person will kick in. And again, a very important, very powerful document. And it's something you should need to sit down with your attorney, power of attorney, and make sure that your wishes are coming to fruition. We mentioned this, communicating life support measures, that's the do not resuscitate. Typically, your POA for personal care is a spouse, relative, or a close friend who is familiar with your wishes and has good judgment, right? You've sat around the dinner table, and I know my mom has said a million times, don't do this, don't do that, right? So I would be in a good position to be her power of attorney for health, because I sort of know what she would want and what she wouldn't want, right? Your POA for personal care can include a statement about who decides if you are not capable of making personal care decisions. And if you don't say anything, your attorney decides this. So we can delve into this a little bit more. This is what I'm talking about, where someone has to, in the case of mental incapacity, it's kind of difficult. If you're in a coma, obviously you can't make decisions on your own, right? Everybody sees that. Sometimes where it becomes more vague or more nuanced are situations where there's a capacity issue, right? And so what we're saying here is that you can include language in the power of attorney that states who decides if I'm incapable of making a decision or not. And your options vary, all right? The options could be the power of attorney, right? So if you elect me to be your power of attorney, I decide that, hey, this person's a little bit squirrely, they can't make these decisions, I'll make it for them, right? Or you can request that be done by a medical professional, right? And that could be a doctor, that could be a psychiatrist, right? I believe we speak about it a little bit more in depth. If you do name someone, your POA usually cannot start making decisions until that person confirms you're not capable, right? You can name a specific person to confirm that you are incapable, such as a family doctor, like I said, or another health care professional, a friend, or even your attorney. Or you can say that it must be a certain type of professional, right? Such as a doctor, social worker, psychologist, or nurse, like I had mentioned. You can also state that you would like your mental incapacity to be confirmed, but not name a person or a profession. This means that it will be confirmed by a capacity assessor. And maybe I should have put that in the definitions, but it's defined there, right? A capacity assessor is someone who has special training and has been approved by the government to decide if an individual is mentally incapable. The Office of the Public Guardian and Trustee, as a branch of the government, has a list of capacity assessors in Ontario. Okay? So, formal requirements for a valid power of attorney. So we had mentioned that it defeats the purpose to draft a power of attorney if it's not done correctly. Okay? And so these are the formal requirements. You can create a POA if you are of age. That's 18 years of age or older for a POA for property, and 16 years of age or older for a POA for personal care, and mentally capable. So we went back to this, you have to be of age, right? The age of majority, well, not really the age of majority, it's outlined specifically what the ages are for the different types of power of attorney, right? And mentally capable. Again, this goes back to capacity. And you're going to see this in the power of attorney drafting. You're going to see this in the wills drafting. A person cannot draft one of these documents or grant this power to someone else unless they appreciate what is happening. Full stop, right? This goes for any document we're talking about with wills and estates planning, and it's a tricky area when I deal with it in real time. You're always searching and making sure that the individual has capacity. What normally ends up happening is there's a lot of elderly individuals that come into the office, right? And they're there with their son and their daughter and their grandkids, right? And mostly the son and daughter and grandkids are doing a lot of talking, right? And they're like, oh yeah, this is what he wants. He wants to give everybody, 30% of the house. And as the solicitor, as I'm sitting there, I'm sort of reading the room. I'm sort of seeing, does this person really, is this what they want? Does it seem like they're under duress is basically what you're looking for, right? You've all seen the movies of the person whispering in the old person's ear as they're on their deathbed and they're signing away their life at the last second. That's what you're trying to avoid, as far as I'm concerned, as a solicitor or anybody who's engaged in drafting these type of documents. I want to make sure you have the capacity. So I'll fully just interrupt the son or the daughter who's speaking and ask the individual, sir, do you understand that you have significant assets here? And depending on their answer, I'll ask them a little bit more follow-up questions, right? If they respond, oh yeah, I know I have the house here, and I have a house in Jamaica, and I have a house there, then I sort of know that they at least grasp what their assets are, right? And then what I also try to do, if I can, is speak to them one-on-one, all right? Because I want to make sure the influence is not there, right? Do you have a question? Yeah. So the question was, has there ever been a time where I had to turn a family away because I noticed instances of duress, right? And I won't say I've turned them away. What I've done is I've forced their hand. So I'll, like I said, interrupt and speak directly to the individual, right? And luckily in that situation, I've never, I guess a better way to answer your question, I've never not been able to assess capacity in any individual, right? It's a tricky situation. I hope I probably eventually will have to, but it's sticky because you're now, you're outnumbered because the whole family's there and they sort of know what they want, right? And you sort of have to give a little bit for the as my parents age, they get a little bit quirky, right? And so it's not always a direct answer. It's not going to be the Queen's English all the time or anything like that or an explanation. It's just, again, the bare minimum, understanding what the assets that you have, what rights you are giving or not giving in terms of naming beneficiaries, right? So what I make sure to do is to try as best. I had one the other day where I was finally able to sort of get, it was a tricky one because this individual was, there was a language barrier as well. So the sons are interpreting for them. So that's very dangerous, right? Because I don't know, I think they were South Korean and I don't speak South Korean, right? So they could be telling me anything, right? And so what luckily happened is I asked to have a meeting with them on the side, and they were just them without the beneficiaries, and they had a financial advisor there with them who also spoke their language. So it's a third party, so I was much more able to trust the financial advisor than I would necessarily the beneficiaries, right? And so that was a much more fulsome conversation, and it came out in that interaction that they actually wanted their distribution of their estate to be a lot different than what the children had first laid out, right? And so that's just a prime example of a situation where you really want to do your due diligence and make sure, and I keep on stressing to the client, it's your wishes. If you want it 90-10, if you want it 70-30, if you want it split equally, it's all up to you, but it needs to be up to you, in my opinion. But that was a great question. Thank you. So anyways, we went off on a little bit of a tangent, but the formal requirements of a valid power of attorney, right? You can create a power of attorney if you're of age. That's we spoke that already. 18 years of age for the POA, 16 years of age for the, POA for property, 16 years of age or older for the POA for personal care, and mentally capable capacity. And what I like, the acronym that will make it easier for you to remember is WSW, right? So that the POA must be in writing. That's the W. It must be signed by the grantor, and it must be signed by 2 witnesses. So writing, signed, witnesses. Okay? So the witnesses can be anyone except the following: your spouse, partner, child, or someone you treat as your child, such as a stepchild you have not adopted but who you support, your attorney, your attorney's spouse or partner, someone, and by that attorney, we're talking about your power of attorney, right? Not your lawyer, right? Someone under the age of 18, as we said, because they need to be up to the age of majority. Someone who has guardian of property because they are not mentally capable of managing their property. So guardian of property is just, in essence, they have capacity issues, right? So clearly they can't be your witness for your power of attorney, right? That would be defeating the purpose as well, okay? And so the reasoning for all of these mostly, capacity is one, when we talk about some, age of majority and someone who has guardian of person. But the prior ones are exactly what we were discussing. That's the conflict of interest, right? Obviously, you don't want someone who's going to be a beneficiary or someone who is going to be empowered by this document being one of the witnesses, right? You want, as far as it would be actually better just to have a random person, right? Or at least someone who's away from the process to be this witness, right? And you require 2 of them. Okay? Now, with these documents, you sort of want to know how to get into them, and then you sort of want to know how to get out of them, right? So, the way you can revoke, or how to end or revoke the power of attorney is that you must sign a notice of revocation. And this is a document that says you can cancel your POA or create a new POA. All right? Again, you got to follow the same process. The same process you got into it with, the same process you're going to use to get out of it with. You must sign in front of 2 witnesses. And the witness must also sign the document, right? Witnessing. And all 3 of you have to be together for the whole process, right? So this is all happening simultaneously, right? We're not doing this on one day and then the witness comes another day and signs. Did you have a question? So the question was, I'm hoping I got your question right, is that on the original power of attorney, you had 2 witnesses that signed, and then when you want to do a new one of the witnesses has passed? And what, you're just trying to create a new power of attorney? Okay, it sounds like an affidavit they're trying to make you sign, swearing that that is true, that this property belongs to someone else, right? That sort of is a little bit outside of the context of what we're talking about right now. It's a good question, and I can, when it's Q&A time, we can revisit it and sort of figure out exactly what type of document it is. But you would know if it was a power of attorney, right? It clearly states, it would be very obvious that it was a power of attorney for property. So I think I asked you, was any power of attorney signed? And you said no. You don't think that they had, that you didn't have a power of attorney for his property, and neither does this other group that's asking you to sign this document, correct? Right. And so in that situation, that's outside of the realm of what we're talking about here with regards to power of attorney. Now, there are estate ramifications. Like if anybody's asking you to sign a document that is swearing to anything, that this property belongs to so-and-so, you should have a lawyer look at that, right? Because I would have to see what type of document this is that they're trying to sign or make you sign, but I highly doubt it's a power of attorney because you would need the formal requirements, right? You would need it to be in writing, signed by the grantor, witnessed by 2 people. That none of that has happened in your right. So oh, okay. We'll in the Q&A we'll revisit that, but I'm pretty sure it has nothing to do with power of attorney. I'm pretty sure, because that would be a completely different mechanism by which that would happen. And remember what we said: power of attorneys end when? Is anybody listening? Exactly. Right. So the moment, if it was a power of attorney, even if it was a power of attorney for your husband or for whomever, right, and that person has now passed. Well, we're not talking about power of attorney anymore at that point, right? We're talking about wills at that point, if he had one, or intestacy situations, right? So that's why we got to keep these things moving. Again, we're talking about a document that strictly deals with while you're living and the property rights with regards to that, right? If the person's not incapacitated, if they're not in a coma or dead or has lost their capacity, they're making their own decisions, right? And they're right there to inform you. You don't have to figure out who owns what. You're going to just ask the person, does that belong to so-and-so? And they'll say yes or no, right? And so that's why it only really comes into play when the person is not around, when you get these vague issues. I hope I answered your question. If I didn't, I'll take time at the end and we can flesh it out a little bit more. Okay? So the way to end, again, the POA is that way. And again, it ends just by itself once the person dies. The person's gone, this thing is no longer relevant. Okay? Now, with all these documents, and this wasn't, before we move on to this, I made a note to myself to make sure, and again, this might be a little bit what's relevant to what you had said with that question, is that with all these documents, when we speak about wills and power of attorneys, you want to keep these documents in a safe place, okay? These are, like I said, very powerful documents. You don't want a situation where we're guessing, did this person have a power of attorney? Did they not? Did they have a will or not, right? And so, there's no formal requirement that the government makes. Like there's no, registry that you must register these documents with. But it's important to put them in somewhere safe and let your attorney, the power of attorney, or your lawyer, know where to find it, right? You want to give them a copy of it. It's also a good idea to give your power of attorney, the person you nominate to be your power of attorney, information about your money and property, right? So there's no guessing game. You keep a list up to date and include information about bank accounts, including the name of the bank and account numbers, insurance plans, retirement plans, things that you may rent or lease, like a car or an apartment, right? Because these are all things that are supposed to be coming into you and your estate, right? And so you need to let the person know, I can't collect on a lease for a rental property that I don't know that you have, right? You can also make a list of dependents, agreements that you have to pay, where you have to pay someone money, like a rental agreement with your landlord. You want to empower your power of attorney as much as you can in terms of information so that they can do the things that they need to do on your behalf. All right. Now, it probably behooves us before we transition out of power of attorneys and into the world of wills, right? To even mention why do we even need a will, right? And the best way to do that is to sort of talk about what happens if you don't have a will, right? Because if you not having a will doesn't mean anything, then why are we even here? This is a waste of time bringing you guys out today, right? And so the next section is what happens if you don't have a will, and this area is called intestacy, okay? Again, not a word you see every day, right? But specifically deals with individuals or estates of individuals who have died without a will, okay? So in the event that you... Oh, great. We had a little bit of, again, the turkeys are back again. It says, two turkeys with their solicitor. James did not leave a will, but he'll still be able to help determine which of you gets his inheritance, right? And she has a wishbone there, if you see. That's sort of an arbitrary way to sort of divvy up the property, right? And so, again... I mean, it's not this dramatic, but it's sort of like if you don't have a will, you're sort of leaving it up to chance, or not necessarily chance, but someone outside of you, right, to make these decisions for you, right? And so I found, again, that's funny because the poor turkeys had their day a couple of weeks ago. All right, so in the event that you die without a will, the law says that you have died intestate. Okay? Remember, we went through that in the definitions. Meaning that you haven't left any instructions as to how you would like your property to be divided and distributed. All right? So what does that mean for your assets? Okay? In these circumstances, your property will be divided according to the laws of the province and the territory you live in. We live in Ontario. Okay? Usually, this is a set formula that the courts will decide on, and ultimately your wishes will or outcomes will not be the same as what the court chooses. So your desires might not necessarily be what the court decides how they're going to divvy up your estate, okay? Negative implications if you choose not to make a will or do not get a chance to before you pass on may include, but are not limited to, right? Your estate may not be divided how you want it to be, right? You might want like I said, a 30-30-30-10 split, and the court's like, no, that's too detailed, right? The court will decide who becomes the caregiver of any children. Again, for those of you that have especially young children, right? You've made no provision as to who takes guardianship or custody of these children, right? This might cause financial and emotional difficulties for your spouse and family, especially for those who are in common law relationships, right? We don't really want to delve too much into the area of family law, right? Because we're dealing with wills and estates law, but there are certainly different ramifications that come into play when you're dealing with common law relationships as it relates to married situations, traditional marriage situations. So you want to keep those in mind, right? You might also have a missed opportunity for any charitable donations, right? Because the government's not going to step in and give 30% of your estate to the Salvation Army necessarily, right? They're not going to respect any charitable organization. They're just going to do what they do. Also, the time it takes to close your affairs may take months and even years longer than if you had just written a will, right? Now, this process takes a long time normally, like even with a will, right? And so you're just adding another layer of confusion and hoops and obstacles to jump through, which is going to be onerous for your family and also for the potential beneficiaries, right? Like, what if you needed a child to get an immediate trust fund payout, right? Now you're delaying that into a later time, which will not be advantageous to you. You sort of want to get this process going as quickly as possible. Okay? So the jurisdiction we are in, obviously, is Ontario. Oh, here's another one. Question for you, Helena. This is the young associate talking to the older partner. A rich man dies, leaving no will. Which of his relatives gets the money? I don't know. None of them. Don't they teach you anything at law school? Well, who does get the money then? And the lawyer brashly, we do, right? And so again, yeah, you didn't appreciate that one. But again, it's like, it's litigation, right? The lawyer's going to sit down there and it's going to be back and forth, and he said, she said, and the lawyer's getting paid, right? The government's making these decisions, and it's just taking away from, even if you're a wealthy individual, it's taking away from the estate that could be used more beneficial in a more beneficial way for the beneficiaries that you want to have interact with it. All right. So Ontario uses the Succession Law Reform Act to distribute your estate if you die without a will, and this is typically the order of distribution. All right? So firstly, if you have a surviving spouse but no children, the spouse gets your entire estate. All right? Again, maybe for 70% of the people out there, that's okay, right? I'd say more often than not, the wills I see, the very first beneficiary is the spouse. That's generally how I see it. But I've seen ones that are not the spouse, right? I've seen ones that are very clear, right, that they don't want a certain dynamic, right? And so, again, in this situation, you write no will, the spouse is going to get your entire estate, okay? The next order of distribution, if you have a spouse and children, the spouse will get the first $200,000, right, of the residue of your estate, and the remainder will be divided equally between the children and the spouse. Again, for some people, that's not a problem, right? But for others, it is, right? They don't want that first $200,000 payout, and then the spouse gets sort of a divvy of what's remainder, right? Maybe they want a more equal, or maybe they want the spouse to get more. Maybe they want the spouse to get less, right? But the government's just going to come in and say, nope, $200,000 to the spouse, and then the remainder divided equally between the children and the spouse. And again, that might not be what you want, right? Next, if you don't have a spouse but have children, your estate is divided equally between your children. If your children have died, their children, your grandchildren, get their share, right? And on and so forth. Again, most wills I see, yeah, it's an equal distribution, but maybe it's not. Sometimes clients come in and I don't want to give my wayward sister anything in my will, right? And so it's your wish, right? And so I say, okay, I tell them sort of the issues that might surround that. We'll talk about later that doesn't necessarily mean that they're not going to have a claim, but I'll explain that to them, but it's sort of the way they want to do it, right? I said the spouse. Oh, okay. If you don't have a spouse, children or grandchildren, your estate is divided equally between your parents. If only one is alive, they get your entire estate. Again, that wouldn't be a problem for me, right? I love my parents very much, right? But other people who are estranged want no part of that, all right? What if your father has been locked up for capital murder? Maybe that's not something you want to do, right? But again, it's up to you. That's why you should just write a will and not have to worry about this, okay? And then again, if you don't have, there's a little bit too much laughing on that one. You guys have estranged families out here. If you don't have surviving parents, your siblings will get your estate. If they are not surviving either, their children, your nieces and nephews, get their share. Okay? Again, might not be a problem for people, but it's food for thought. This is the order of distribution, right? Cold calculated, that's the way they do it. If you're okay with that, then I guess you take your chances and you don't create a will. But this is what you're up against if that situation were to ever occur. Okay? All right. So we've gone over, obviously. Is there a question? Yeah. Yes. So the question was, what's the turnaround time if an individual dies intestate, I believe is the question you're asking me, all right? And again, unfortunately, I'm going to give you the lawyer answer, and the lawyer answer is it depends, right? And I know no one likes to hear that question, but I'll tell you why it depends. It depends for a lot of reasons. It depends due to, for example, what's the biggest excuse these days when it comes to why things aren't done on time? Thank you, right? COVID, right? That's the biggest excuse out there. Oh, I didn't get that document in. Yeah, COVID. And you're like, hold on a second, wasn't that a year and a half ago or whatever? But that's the excuse. And so, but I do bring that up to say that while COVID was happening, whatever backlog existed grew exponentially, right? And so I'm not using this excuse, right? Because it's not the lawyer that's filing it. It's literally a completely separate branch of the government, right? That is, especially when we're dealing with intestacy rights, like they're dealing with it wholeheartedly, right? And so there could be a delay with regards to that. Also, the reason it depends is litigation, right? So I gave you the example of a situation where someone gets less than they probably think they deserve for whatever reason, right? Well, we're seeing you in court, right? That's going to happen. Someone's going to make a claim on the estate, right? That's going to pause all of these proceedings, right? Or at least interrupt them, right? And so that can also add time, right? To give you some sort of, if I'm going to give you a range, I would say I've seen it done as quickly as a few months to as long as, man, I want to say I saw one the other day that was like from 2011. That was a will though, and that was contested. That wasn't intested. So I think you were asking how long this process takes, right? Normally, and I shouldn't speak in generality, but normally people who die intestate are people with less complex estates, if that makes any sense, right? And I want to say this, in a crafty way, right? But so normally there's not much to it, is what I'm meaning by that, right? Maybe it's an estate that's only like $2,000, right? They died intestate, big deal, no one's really fighting for it. That's not going to take very long. That's going to be solely however long it's taking for them to process documents right now, right? Which is, I haven't checked, I haven't done an intestacy in a while. But typically that's what is dependent on. It depends on how complex the estate is. If it's a very complex estate, you're going to be there for years because many people are now fighting for money. A person is claiming that they were a dependent. I'm this person's child. I deserve rights, and I'm not. Your laws are not sort of taking into consideration my needs, and we're going to be there forever, right? But it does add, I would say, net, if we're talking about everything, all things being equal, this process would take, I can't even say that, could take longer than a normal process. Because with the will, it's defined, right? We know exactly who's getting what, and we also know it was the grantor's wish. It would be very difficult to come into the situation Johnny come lately, right? When someone had a will and say they didn't want to write me out of the will. As a matter of fact, if I'm writing someone out of the will, I'm putting language in there specifically stating that the grantor understands that this person is not part of the will and doesn't want them in the will for this reason, right? Because it's going to be a problem. It's going to be a fight later on, right? With this, there's much more ambiguity, right? Like, did the person, I don't know, like they just didn't make a will, right? I know my father loves me and he would never have given me only, the remainder after the first 200,000. He hated his wife, right? She treated him so horribly. These are the type of interactions that end up happening. And then who's to say, right? It's like, now, well, that's why you should have drafted the will, right? And so that's where it becomes a little bit more lengthy. I mean, we're almost there now. I was just segueing into what is a will, and that for all of you who will dutifully come back a week from today, we hold you in suspense so that you come back, right? We're going to sort of delve into, we've sort of gone over why a will is important, right? And now I can explain to you sort of what is a will, what goes into it, the formal requirements as well, and things of that nature. We're not playing this video this week, are we? Oh, we are. Oh, excellent. So we have a little video here for you, and I'll step aside for a moment and come back for Q&A. Okay?
Hey, so y'all can do all this renovation work, and you still can't call the estate planner that I connected you with?
See, we knew you were gonna ask, so there you go.
Y'all wrote your will in pencil?
Well, I had to erase a few things because Jerome pissed me off.
Mom, Dad, this limp, loose leaf of paper does not qualify as estate planning. You actually have to go through lawyers.
Hey, Molly.